Thank you very much, Florian. Merci. It's a great pleasure for me to be here tonight and to see so many faces here in the room. Florian has asked me to start by briefly introducing what we actually mean by algorithm. I think everybody had at least a vague notion of this term, otherwise you wouldn't be here. But to put it very, I'm just going to make this small for the moment, so that you look at me and not my website yet. So what's an algorithm? An algorithm is basically a blueprint to solve a given problem. Of course, there are many types of blueprints to solve problems out there. I might have a blueprint how to create world peace or to how to write my next research project. But what sets algorithms apart is that this blueprint is based on an inherent and formalized internal logic, so that I can hand this algorithm, this blueprint, then to somebody else, and he or she could then implement the same algorithm and solve the same problem in the same way. So we can not only give algorithms that then from one person to the other to solve the same problem, but we actually can also hand it to a computer because it is based on this nice logic. So we can listen to music, so we can solve problems not only as humans, but also then by referring it to a computer. Now, on the one hand, that is something that is maybe not terribly exciting for most of you, because most of these algorithms are based on mathematics, and most of you, or perhaps some of you, only have chosen to become lawyers because you don't like mathematics. And so this is maybe bad news that most algorithms are based on math. But there are also some algorithms that are based on pure logic, so decision trees where you decide, if I do this, what is going to happen afterwards, that can also then be formalized as part of an algorithm. Now, to cut a long story short, so algorithms are about these formalized rules that allow us to solve certain problems. And the reason why we are here is that actually today, we're able to solve a lot of more problems with the help of algorithms that we used to. And that now brings me to my presentation, and I'll show you the website that I'll be using for this presentation in a minute. Because when we go back in time, maybe 10 years ago, and I would be giving this talk, how we can use algorithms to map the law, you could have laughed at me, and you would have had good reason to do so, because algorithms, as I said, are based on rules. Right. And the world is really messy, so it's very hard to distill the messy world into rules and into algorithms that help us make sense of this world. And so 10 years ago, for instance, there was consensus that we would never have self-driving cars. We knew that we were probably going to be able to write the rules to have a car brake, just if it gets too close to another car, or to teach a car how to self-park. But writing all the rules so that a car could drive, that would have been impossible. Similarly, lawyers, the legal informatics community, spend a lot of time thinking about legal expert systems, so to devise the rules that would guide users after asking them certain questions. What type of liability have you incurred? What type of remedy can we propose? These legal expert systems were basically hard-coded expert knowledge. And of course, then, with this logic in mind, it would have never been possible to have something like a robot judge, would have robots write treaties or contracts. But in the past 10 years, this has really changed dramatically. Computers can not only be used to follow simple rules, but they can actually recognize patterns. Computers, to some extent, can be creative. And because we now have these novel algorithms, it is really high time that we use a panel like this to talk about them. And so, as I said, I'll be kicking this off by talking about how we can use these algorithms to map the law. I'll show you 3 different algorithms that I've used in my prior research. And that will go from, well, this is kind of interesting, to, well, this is interesting and it might actually be useful, to something like, wow, I didn't know that is going to be possible. At least I hope that you will have this type of reaction. So let's start with sort of something very basic to ease into that topic. So as Florian said, my research focuses on bilateral investment treaties. So there are 3,000 bilateral investment treaties out there. And one of the challenges that I had when I first started thinking about this universe of treaties is, well, how do I actually map the content of these agreements? I didn't want to read 3,000 agreements. I wanted to have an algorithm that helped me to make sense of it. So an algorithm that would help me to map the law. And so the first algorithm that we used for that was a very simple one. We just compared the textual similarity of two legal documents. And you might say, well, textual similarity doesn't really get to the meaning of the law, and I would agree with you, but at the same time it did teach us something useful. So here, for instance, you see the heat map representation of 1,600 investment treaties. So the same treaties are compared on the X and the Y axis. If two treaties are identical and wording are very similar, it will be represented as red in our heat map, while if they are very different, they will be represented as yellow spaces in our heat map. Every tile of that heat map is a comparison between two treaties. And so what we saw is that if we order this heat map then by the richer party in a bilateral investment treaty, we get these neat patterns where we see the UK having very internally consistent treaties, Germany having relatively internally consistent treaties. So we saw that the consistency of an agreement is linked to the development of a country, because once we sort it then by the less wealthy party, you see that these patterns disappear. And that taught us something about investment rules, that developed countries are the rule makers of the system, while developing countries are the rule takers of the system. So again, maybe something interesting, maybe not mind-blowing. So how can we turn this into something that's even more useful? So we thought, well, we want to enable our users then to dig into these treaties and to see if two treaties are similar or different. Lawyers want to know why they're different, so to enable them to compare articles, for instance. And that's what we did. So we developed a second algorithm that matched articles within two treaties. But of course, it's quite difficult without reading them to know which articles in two treaties correspond. So we wanted to have a nationalization clause in one agreement correspond to an expropriation clause in the other agreement because they cover the same subject matter. Now, but one of the problems we face is that some of our treaties, they didn't have article headers. So they didn't have any clue that would tell us what this article would be about. So our second algorithm was a so-called machine learning algorithm. And that's sort of part of where the journey is now going with respect to these smart algorithms that not only follow rules like what we had before, just comparing text, but actually learning from patterns, rules that we as humans didn't even give them. And so we taught the computer to label articles without headers by feeding them with articles that had headers. So we trained it on labeled articles, and the computer itself labeled articles, allowing us to compare these two agreements then article by article. Now you might say, well, this sounds like something useful, and it can be applied really in a variety of different sections of the law. But what I think is hopefully the most mind-blowing is a project that we did recently where we try to go one step further, not only having computers analyze treaties, but having computers write treaties. So can robots write treaties? And so what did we do? We used a deep learning algorithm, a so-called neural network, and we trained it with our investment treaty texts. And then this neural network predicted letter by letter new clauses on the subjects that we fed into them. So for instance, here you see, we built an entire sort of system around it where users can then change the bargaining power. So here we are predicting a transfer clause in a treaty between the United States and China, where both countries have equal bargaining power. Here, China has 100%, so China has the greater bargaining power, and here's 100% US treaty. So this glitch. So, but the basic takeaway message from this is that we were able to teach a computer to autonomously write investment agreements without teaching the computer anything about the law. It was purely by picking up and by being trained on these existing treaties that the computer sort of got creative and wrote its own agreements. And I hope that if I get some of you excited about this, that you help me make sense of it, because it's actually, these are what they are called black box algorithms, so we don't really know what they do, we just know that it works. And I hope in the future to do more work on that, to identify how creative are these clauses. Are they just reproductions of what we already have? Is there really something else that we could use, for instance, to support negotiations? And finally, what are other applications of this? So this is about treaties, but we could apply the same thing for contracts, and sort of have a robot writing contracts on demand, not by just picking a template that exists, but writing a new contract from scratch. And I think that's a very exciting future if you are maybe not the lawyer, but the lawyer working on these types of things, because of course it might have repercussions on future of the legal profession. But again, this is what makes this all exciting. So I hope that you've enjoyed this little excursion into investment treaties and algorithms, and I'm looking forward to the discussion. Thank you very much.
Okay, so I'm going to talk about algorithms and discrimination. And one of the things that algorithms, particularly in online environments, are designed to do is, in fact, to discriminate between entities, to figure out who has an interest in a certain kind of product, typically, and to gauge, in many instances, marketing campaigns toward people who are perceived to be members of groups who may be interested in this kind of product. But the kind of discrimination I'm talking about goes beyond that sort of general term of discrimination in the sense of distinguishing or choosing between one or the other of something. But to think about distinctions that are made between people that are based on grounds that we've recognized in law are prohibited grounds for discriminating. So gender, sexual identity, race, religion, ability, indigeneity, and so forth, where consideration of those grounds and certain kinds of decision-making around, whether it be around employment, opportunities, or educational opportunities, or pricing decisions, offers of places to live, where we have recognized in law that these are unacceptable bases upon which to discriminate between people, and to try to think about that in the context of the operation of algorithms in the online environment, and particularly relating to behavioral targeting. In the Equality Project, we're interested in the impacts of behavioral targeting on young people and trying to unpack the degree to which behavioral targeting in these models are premised on prohibited grounds of discrimination and or perpetuate existing forms of discrimination in one form or another. But I'm going to talk about a couple of examples of those that we know about. But first of all, I always love going back into ancient history to find people who already knew that these things were going to happen way before they happened. In 1993, Oscar Gandy, who many of you will know, wrote the book The Panoptic Sort, A Political Economy of Personal Information. And he described the panoptic sort this way. I've assigned to the complex technology that involves the collection, processing, and sharing of information about individuals and groups that is generated through their daily lives and is used to coordinate and control their access to the goods and services that define life in the modern capitalist economy. He said, basically, this would involve 4 steps. It would involve identifying characteristics or issues that were considered to have administrative or instrumental relevance to the decision that was about to be made, whether it was to extend credit to someone or what to pull up first on your Google search, although that wasn't in his mind in 1993. The second step involved classifying individuals into groups according to these characteristics characteristics. And the third, assessing individuals according to some administratively defined aggregate. And the impact on the world, he predicted, would be observable and highly problematic. He said the panoptic sort would operate as a kind of cybernetic triage through which individuals and groups of people are being sorted according to their presumed economic and political value. The poor, he said, especially poor people of color, are increasingly being treated as broken material or damaged goods to be discarded or sold at bargain prices to scavengers in the marketplace. In addition, he said, and I think this has been important in our work in thinking about the impact of being sorted and addressed and categorized according to this kind of sort on individuals' perceptions of and understandings of self, particularly young people. He said. So he put it this way. He said the impact of the sort would not be just the external consequences of inclusion or exclusion, but the more insidious impacts on individuals' understandings of themselves. Individual identities, he said, are formed in interaction with others. The characteristics of those interactions help to determine the salience as well as the level of comfort with which different aspects of one's self coexist. Self-esteem is determined in part by the ways in which one's relevant reference groups are evaluated by others. So if we flash forward 24 years to this conversation that we're having today, what we see in the context of the online sort through the data that all of us trade for access to online services and other kinds of information, we see lots of examples of the ways in which the potential for discrimination on the bases that we've already determined in law are not acceptable social bases for making decisions or distinguishing between people in terms of giving access to certain kinds of goods and services. In particular, are well at work. We have there's so many examples. Those of you who heard Lutanya Sweeney speak earlier this year discovered through analyzing Google ad searches that African American sounding names were more likely to turn up ads offering criminal record searches. And so there was a distinction, obviously, that was being made, or that resulted in a distinction based on race that otherwise is not would not be permissible. We see some Carnegie Mellon research that showed that Google users visiting, it created new personae online and visited certain employment sites, and then went to third-party news sites. And Google ads turned up ads for career coaching services, advertising $200,000 per year plus executive positions. But in their experiment, it showed that the ad for these more prestigious, high-paying positions, 852 times to users who were identified as men, and only 318 times to users identified as women. What we don't know, and this is part of the mystery of the black box, and what's at stake in the mystery of the black box in these kind of applications, is exactly what is going on. Is it a mirror of society? Is the search engine merely turning back a reflection of the prejudices that exist in society? Is the advertiser actually targeting for certain kinds of characteristics? Google, in this case, actually wouldn't say. ProPublica research discovered discrimination in the prices being charged for SAT prep tests. Asians, they discovered in their experiment, were almost twice as likely to pay a higher price for the course because they are Asian or because they live in certain zip codes So it captured Asian people from both high income and low income areas. So these are just isolated examples. There are many more. They may be at work in every day when you're conducting your Google searches and your results are different from the person who's beside you or not. And we see that we are making predictions about people that either are based in distinctions that we've said are not a permissible basis for making distinctions between people, or they have a disparate impact according to people's belonging to particular groups who enjoy protected and deserve protected status at law. So what's the upshot of what I'm saying? I guess it's a note of caution. I think one of the minimum things we need is greater transparency, which I think as we move into machine learning algorithms, we're not going to get, because we won't have the capacity to actually understand what is actually happening. We need to look at companies that are using algorithms as bases for decision making and figure out how we can create some form of human accountability for what is going on and for the impacts that these kind of decisions can have on people's life chances when they're based on grounds that we have chosen very deliberately and specifically as a representation of our public policy to say are not appropriate grounds for certain kinds of decision making. So I guess what I'm saying, I'll paraphrase Langdon Winner here, is as he suggested in 1986, as we go about making the world, we have to ask, what kind of world are we making? Thank you.
All right, I'm going to take you on a slightly irreverent tour of a case coming to a Supreme Court near you this January. Title, I couldn't decide which title to go with. Where there's smoke, there's a database, or all your bases belong to us. You'll see why both are relevant. First, a little bit about CIPIC. We're the university's technology law clinic here. We're based at the Faculty of Law in the Center for Law, Technology, and Society. Our mandate is to intervene on behalf of the public interest on technology policy debates arising at the intersection of law and technology. It's a fun gig. We work with students as volunteers, as student interns, as summer interns. So hopefully I'll see many of you through the doors of the clinic in the next year or so. So first, let's talk about the case. It's British Columbia versus Philip Morris International, or Supernatural British Columbia v. Joe Campbell. This is how you'll probably run across it in your courses if you look at this case. Recent decision out of the BC Court of Appeal. It's all about the Tobacco Damages and Healthcare Cost Recovery Act. A little bit of legislation that enables provinces, every province seems to have one, enables them to recover healthcare costs incurred due to tobacco intake. The heavy lifting piece of the legislation is Section 2.1. It says the government has a direct and distinct action against a tobacco manufacturer. And there's two ways to do it. One is to recover actions for particular individual insured persons. So if you have a grandmother in British Columbia deceased who was a heavy smoker, there may be a claim for the government through that route. Or of more interest to us here, on an aggregate basis for a population of insured persons as a result of exposure to a type of tobacco product. So all the action comes in subsection 5, 2 sub 5, which is a little exclusion for personal information in the context of aggregate claims. So when the British Columbia government goes after a tobacco company for recovery on an aggregate basis for a population, there's a privacy exception. And the provision in case, or the provision that we're talking about is really Section B, sub B, which says that the healthcare records and documents of particular individual insured persons or the documents relating to the provision of healthcare benefits for particular individual insured persons are not compellable. So they're not discoverable. The tobacco company cannot look at the personal health records of individuals. Now, there's two exceptions to the exception. One is in the context of expert witnesses, and second, a tobacco company can ask for a statistically meaningful sample, and they can look at those records if all identifiers are deleted from that sample. Those are the two exceptions. And of course, there's the initial claim that if the government goes after a tobacco company for an individual's healthcare costs, then the health records of that individual in that individual claim, not the aggregate claim, are compellable. So that's the setup. So what happened? British Columbia said, hey, we're going to sue you for recovery of aggregated health costs. Philip Morris said, well, we want to see all your databases of healthcare records. And British Columbia said, no way, there's a privacy exception, section 2 sub 5, do you read it? And Philip Morris said, that only applies to patient records. It doesn't apply to databases. The ordinary rules of discovery apply. All your bases belong to us. They went to court over this issue. Not that court, that's the old court. Now it looks a little bit more like this. And in a decision released in 2015, Justice Smith, that's not a picture of Justice Smith, he said, disclose the databases. He said, Section 5.2 protects patient records, not databases. And regardless, if the province's interpretation is correct, the province can prove its case using statistical evidence that it has in its possession while denying the defendants access to that same evidence. And that's just not fair. The court went on to conclude that there was no evidence to explain how that detailed history could be linked to any named individual, and therefore there was no evidence of possible invasion of privacy. And British Columbia said, dude, we're appealing. So they went back to court, and the Court of Appeal handed down its decision earlier this year, and they affirmed the lower court decision. They said, first of all, okay, the bit about patient records and databases, we get it. The databases count as patient records. So at least that little bit of, that little mistake is gone. We don't have to worry about that. But nonetheless, the court went on to say that this is a case of statutory interpretation, and privacy of individuals was not the paramount concern of the legislature in enacting this provision. Instead, the court said that, Court of Appeal said it's clear that individual records are compellable in certain circumstances, and so it can't just be all about patient privacy. But then this is a case of statutory interpretation and privacy. Oh, pardon me, this is the same thing twice. The court went on to conclude, in the end, once stripped of personal identifiers, disclosure of the anonymized data poses no realistic threat of personal privacy. And British Columbia's response was, again, dudes, we're appealing. And off we go to the Supreme Court of Canada. They filed their application for leave to appeal, and they made a few interesting arguments. First of all, they said there's another decision on this same issue out of New Brunswick, and the New Brunswick court came to the opposite perspective. So we've got conflicting decisions, matter of public interest. You must grant leave, Supreme Court. And Philip Morris's response was, you don't need to deal with this. You've already dealt with it. You denied leave in the New Brunswick case, so let it rest. British Columbia's second argument was that the BC Court of Appeal effectively said that fairness in the discovery process overrides privacy concerns, and that's wrong. Privacy is a constitutional right. It's got extensive quasi-constitutional protections in various statutes in BC, and Philip Morris's response was, nah, this is just discovery. The third major argument was procedural rules protecting privacy are a matter of public interest, and so even if all of Philip Morris's arguments are right that this is about discovery, that's still important and worthy of the Supreme Court's attention. Philip Morris's response, producing anonymized data in discovery poses no privacy risks. On the facts, privacy is not at stake in this appeal. Supreme Court granted leave. Granted leave, the case is going to be heard on when is it? Did they say when it is? Oh, there it is. They said it's going to be January 17th in 2018, so coming up really quite quickly. And this is an interesting case for us. We've got some things that I think we might want to say in this case. We've been talking to your friend Teresa Scassa about this, and she shares our concerns. First, there's an awful lot of faith placed in anonymization. There's a great deal of work that's been done out there. Latanya Sweeney has already been mentioned in this presentation. Paul Loam wrote a great piece on the surprising failure of anonymization. It's a myth that anonymization is the silver bullet to deal with this, particularly when you consider that this court is not talking about obfuscating the records. They're simply talking about stripping personal identifiers. My guess is that it would be fairly simple to cross-reference the databases we're talking about with other publicly available sources to re-identify many of the people in the government databases. And second, there's a framing problem. This is framed as privacy versus procedural fairness. When we talk about databases and we talk about algorithms, and this really does get down to the government's algorithm for figuring out how much money these tobacco companies owe it to compensate it for healthcare costs. It's an issue about accountability and transparency. We want to be able to see how the decision that's being made, how the decision that's affecting us is being made. We want to be able to get in there and muck around a little bit. This isn't the case of black box algorithms where we don't know how the government figured out how much the tobacco companies owe the province. We figure that there's an algorithm out there and it's pretty straightforward. I'm sure the tobacco companies feel the same way. So we think the framing, the way that the argument is being framed is all wrong, and that we can make some contributions to the court's decision in how it attacks this problem. Because I don't think this is the first time that we're going to see decisions based on databases go up to the Supreme Court. Thanks a lot.
Great, thanks. So before I begin, let me just start by saying that for years, my colleagues, both here and who aren't in the room necessarily right now, had visions of creating a program here where we'd have a real community of people interested in law and technology. And I have to say that as I look out and see new students and students who've been around and traveled with me and others on different programs, and graduate students and people who have graduated from a program, as well as faculty and people from the tech community generally within Ottawa, everybody coming together. It's enormously gratifying, and it's fantastic to see people come together on these sorts of events. And I encourage you to come out not just today when you get pizza, but on many of the other events that we've got planned throughout the year. I'd also note that when we think about this particular panel, several months in advance, we start thinking about, well, what's going to be a hot topic that can get people out besides the pizza. And this year, obviously, we landed on algorithms. And I have to say that I knew we hit on the right topic literally a couple of hours ago. I was sitting in my office just before coming down here. And at 4 o'clock, ProPublica, which Jane referenced, released a new story in which it disclosed that they revealed that Facebook has been offering up the ability for people who want to advertise to people who are interested in Jew haters, the ability to target specifically to that segment of the population. There are apparently about 2,300 people that you can target, and they use terms like Jew hater or why Jews ruin the world. Facebook's response to the story is, as you might expect, this was not a human that created this particular advertising opportunity. It's an algorithm, and we'll do better in terms of trying to check some of those algorithms in the future. And so these kinds of stories, that's a different kind of discrimination from the one Jane was referring to, but pretty particularly loathsome one, are the sorts of issues that are going to come up a lot. And particularly around the transparency, and Jane mentioned it as well, is also an enormous issue that I think we're going to be grappling with for some time. Now, the challenge that's often posed in the context of AI is really, in a sense, there's two ingredients here. I thought Wolfgang's presentation highlighted it. One is the algorithm itself, that blueprint as you described it, and you talked about sometimes it's a bit of a black box. That's the part that Facebook, in this particular example, is saying, well, it just generates it, and we need to do a better job of trying to stop that from happening, but, it's just the computer. The other, of course, is the data itself. Right? So in Facebook's context, the reason that they've been as successful as they are is they've got a lot of data. I'd venture to say many people, if not most people in the room, actively provide Facebook with some of that data. And so they do as well as they do. Sometimes they know it, sometimes they don't, but they're providing lots and lots of that data. Now, one of the interesting things that I wanted to focus on, or at least I think is interesting, is the data side of it, that information that goes into this machine learning and the sort of algorithms and AI that we talk a lot about. Now, in Wolfgang's example, apparently, in order to teach a computer how to draft a treaty, you need a couple thousand of those treaties, presumably all fairly similar, but nevertheless, give it a couple thousand of those treaties and you can make it smart enough to draft one of those treaties. The example that I often reference is translation. How do you make a computer smart enough to effectively translate from one language to the next? And I'd venture to say it takes more than a couple thousand treaties to be able to do that. Now, we've got a good real-world example of a company that's tried to do that, and I would venture to say done it fairly well, and that's, of course, is Google. And just as I'm sure many people here, if not most, are on Facebook, many people, if not most, have used Google Translate at different points in time. And if you've been using it for a while, you know that early on it wasn't particularly good. It was pretty clunky, to the point that if you wanted to try to fake that you could speak another language, you could use Google Translate, and it was pretty easy for certainly a native speaker to recognize that what you were providing was a computer-generated translation rather than someone that actually knew how to speak the language, speak the language well. And the challenge that Google was facing was, in a sense, both of those ingredients. They were, on the one hand, having to grapple with the algorithm side of it, the technology, the code, to try to parse out how you make a computer spit out a translation that isn't only a direct translation, but also reflects the idioms of a particular language. But then they also needed as much data as possible, or data, to try to allow it to identify when someone says something in one language, what it would be in another language. Now, early on, they were looking for data sets that would allow them to do that and come up with accurate information. And what they landed on, by and large, was government documents, especially those from the United Nations, which creates official translations in at least the 6 official languages. And there are other governments, of course, including our own, that will translate actively all sorts of documents. And so you can use that kind of information to provide you with direct and presumably very accurate translations of the same documents. The problem is that not a lot of people talk like UN documents. And so you can come up with translations, at least for those kinds of documents, but it isn't going to reflect the sort of translations that people will actually be looking for that reflect the way that they speak. And so the solution, and the reasons that we've seen Google get better over time, is one, they've got better in terms of the algorithmic side, but the other is that they've got better data coming in. Now, they've done that also in 2 ways. One is that they've crowdsourced asking their users to give better translations or identify when particular translations aren't very good. And so anytime that you input something for translation into Google Translate, it will ask you, is this a good translation? It'll also often give you a couple of other alternatives, and you can select the one that you think is best. And so they're, in a sense, relying on their billions of users to do some of the work for them, where someone may know whether or not this is a good translation or not, and it can help correct or self-correct over time. But even more, what they've needed is as much data as possible, and they needed to get away from some of those official translations. One of the solutions that they ultimately began using is, of course, literature. And if you scan or digitize as many books as possible, many of which will have been translated into multiple languages, you begin to find more and more content that is translated into multiple languages themselves. And we've seen that, of course, with the Google Book Search Initiative, which gave them a treasure trove of tens of millions of books, many of which might well be the same books, but made available in different languages. Now, this particular area, this field of taking large amounts, massive amounts of data, and using it not to republish, they're not interested in republishing those books or other sorts of text, but rather taking all of that data for the purposes of engaging in data mining, is a field known as text and data mining. And it brings me to the issue that I really want to talk about in the last 2 minutes that I've got, and that's the copyright implications of taking all of that kind of material and using it not for purposes of posting the content or republishing the content or things of that nature, the kinds of things that we would typically think about in a copyright context, but rather simply using those works now for data mining the actual content, because I can discern certain bits of information out of it and use it in some certain ways. Now that has emerged in recent years as a copyright issue, in part because publishers and others say it may be the case that you're not actually republishing what I've written, but you're garnering or gleaning some value from my work. I should have the right to either stop you from doing it or be compensated or licensed to you, the right to have digitized or at least used these works in these kinds of ways. Now, if we were to stop and say before you can engage in this kind of text and data mining, you've got to obtain permission from every person and every work, it would stop these sorts of projects dead in their tracks. And so what do? You look to whether or not there are mechanisms within the copyright law to permit whether or not, and you can have the debate as to whether or not it should permit these sorts of activities without the permission of the copyright holders themselves. Now in the United States, Google's presumably engaged in these activities because of the fair use provision that exists in the United States, which is seen as sufficiently flexible to cover these sorts of issues. In other jurisdictions, though, many of which don't have fair use, they've actually now created specific text and data mining exceptions. So in countries like Japan or in Britain, they've actually got text and data mining exceptions, which itself raise a whole series of interesting policy questions. So in some jurisdictions, they've got TDM exceptions, but they only allow for non-commercial text and data mining. And so they say, well, if you're doing this for a research project or other non-commercial purposes, we'll permit it. But as soon as you want to commercialize those works, you need permission. In other instances, they've said if under, let's say, you've obtained access to many of these works in digital form to begin with, they've said even if the contract says you can't do certain things, we might essentially allow you to override contractual restrictions and still engage in this text and data mining, so little is the impact on the underlying rights. Now, from a Canadian perspective, and this is where I hope many of us will get engaged on some of these issues, we don't have a text and data mining exception, and we don't have fair use. Now, we've got a pretty robust and flexible fair dealing provision that arguably will cover some, if not most, of these activities. But at a time when we're increasingly focused on AI and on some of the potential that much of this has, especially if you're thinking about engaging in these activities as a startup, let's say, or otherwise looking to commercialize some of these activities, it raises the question as to whether or not our laws today provide us enough certainty to allow someone to engage in widespread text and data mining, relying simply on a fair dealing provision, such as arguing that this is for research or other sorts of purposes. And so as the government here in Canada begins a copyright review later this year, scheduled to start in November, or at least launch in November, there is an opportunity for us to think not just about what we did several years ago with respect to copyright reform, but also begin to be increasingly forward-looking when it comes to copyright. And I'd argue, think about whether or not we need a specific text and data mining, well, whether or not we need fair use, and whether or not, if we don't get fair use, think about expanding the fair dealing provision to more explicitly include something like text and data mining. Stop there.
Okay, so I'm going to talk about the ethics around self-driving cars, and I'll probably go back and forth between saying self-driving cars and autonomous vehicles. And I want to start with something called the trolley problem, which many of you may be familiar with. It's a moral and philosophical thought experiment that was created in 1967. And the idea is that you've got a trolley, and it's barreling down the track. Something's probably gone wrong with its brakes. And if it goes on its current path, it's going to take out 5 people. But there's a switch in the track, and if you pull the lever, it will take out 1 person. And so it basically gets at this idea that your actions have consequences. Regardless of whether or not you make a choice, something is going to happen that affects these people. So if you do nothing, 5 people die. If you do something, 1 person dies. So it's often posed as sort of this vision of utilitarianism. And in fact, most people, when they're surveyed, do choose the utilitarian option. The fewest lost lives is the ethical thing to do. And this picture is representative of how it's usually depicted. So sort of cartoony, even though it's a macabre dilemma here. And also notice the people are clones. They're basically all fungible. So you're not choosing between real different people. You're just choosing 5 versus 1. Okay, but what if you know who the person is? So what if you are Flanders and you're trying to decide, do I take out Homer or do I save Stewie? Does that change the ethics of it? Suddenly it seems a lot more premeditated if Flanders makes a choice to take out Homer. So a classic variation of the trolley problem was created by Judith Jarvis Thomson, where she's got this, she loves her quirky variations here, where you've got somebody on a bridge with a large mass. If you push them off the bridge, they'll be big enough to stop the barreling trolley, and therefore 1 down, 5 saved. When you ask people this question, most people no longer want to push the guy off. They'll push the lever, they won't actually push a person off, even though the numbers are exactly the same. So Carnegie Mellon did a study, and 55% of people would push an avatar off the bridge. When their hand went through and touched a warm body, that number went down to 30%. Research at Princeton also showed, through fMRI, that different parts of the brain were engaged. When you pulled the lever, it was a cognitive decision. If you pushed a guy off the bridge, it was emotional. Okay, and so we can also think about this again with Flanders. If he's pushing comic book guy off the bridge, is this a less ethical decision than if he doesn't know who it is? Okay, so there is a 5-year-old decision to this question. Or 2, I guess he is. Hopefully the volume works here.
Uh-oh, Nicholas. This train is going to crash into these 5 people. Should we move the train to go this way, or should we let it go that way? Which way should the train go?
Sort of seemed like Nicholas was going to go in a different direction there.
The trolley problem is a thought experiment where a runaway trolley is rushing towards 5 people in one
So the trolley problem has been criticized a lot. Who rides trolleys anymore? Unless you're in San Francisco. Why can't you just shout to the people, move? If someone was big enough to stop a train, how are you actually going to pitch them over the bridge? But the trolley problem is strangely relevant again. It's actually what's going on with the ethics of algorithms for autonomous vehicles. With self-driving cars, we have to make a decision. The algorithm has to decide swerve or not. And if it swerves, swerve where? So,
but you have an option to pull a switch and divert the trolley to a track with only 1 person. Quick, do you pull the switch? Most people would say they would pull it, as 5 lives are greater than 1. But what if instead of pulling a switch, there's only 1 track with 5 people? And you have the option to push 1 large fellow off a bridge and stop the trolley. Would you do it? The math of the situation has not changed. It is still 1 life for 5. When the problem is rephrased in this way, many people change their minds. This problem is often used by philosophy professors to illustrate that people think the act of pushing someone to their death is worse than pulling a switch that will cause a death. As the philosophy class goes on, increasingly complex variations of the trolley problem are brought up, including what if...
There we go.
This is a thought experiment. Let's say at some point in the not-so-distant future, you're barreling down the highway in your self-driving car, and you find yourself boxed in on all sides by other cars. Suddenly, a large, heavy object falls off the truck in front of you. Your car can't stop in time to avoid the collision, so it needs to make a decision. Go straight and hit the object, swerve left into an SUV, or swerve right into a motorcycle. Should it prioritize your safety by hitting the motorcycle, minimize danger to others by not swerving, even if it means hitting the large object and sacrificing your life, or take the middle ground by hitting the SUV, which has a high passenger safety rating? So what should the self-driving car do? If we were driving that boxed-in car in manual mode, whichever way we'd react would be understood as just that, a reaction, not a deliberate decision. It would be an instinctual, panicked move with no forethought or malice. But if a programmer were to instruct the car to make the same move, given conditions it may sense in the future, well, that looks more like premeditated homicide. Now, to be fair, self-driving cars are predicted to dramatically reduce traffic accidents and fatalities by removing human error from the driving equation. Plus, there may be all sorts of other benefits: eased road congestion, decreased harmful emissions, and minimized unproductive and stressful driving time. But accidents can and will still happen, and when they do, their outcomes may be determined months or years in advance by programmers or policymakers. And they'll have...
Okay, so one of the things that's changing with self-driving cars and the algorithm is that now, rather than you being in the godlike position of choosing what someone else will do, now you potentially are the one that gets offed by the car. And so this makes a difference for us as a society because self-driving cars are predicted to be way more safe than cars driven by humans. But if you can't get people to buy them, then they're not going to be deployed in large numbers, and that too will result in accidents and losses. So if you've got a marketing ploy and you've got an advertisement on TV and your car is being shown as something that's going to pitch you off the cliff, not too many people are going to buy it. And in fact, this has been set up by research which asks people these questions. And so they pose the idea, should a car make a utilitarian choice? Should it choose to take just one person, swerve toward one, rather than swerve toward five? The vast majority of people strongly agree that it should be utilitarian. But if you ask them, if you are the person driving the car, should it sacrifice you to save five people? The vast majority of people say no. So you've got this self-interest versus the utilitarian numbers of trying to save the most people on the road through the coding of the car. In a recent study, people were also told different laws before they made whatever their decision was. So in one situation, they were told it would be criminal homicide to swerve the car toward more people. And so people followed in vast numbers whatever they were told the law was going to say, even if they were told the law wasn't going to be enforced against them. So you have this sort of technological law feedback loop where people are taking their ethics from the technology and the technology is taking its ethics from the law. But we have not well thought out yet who it is that is making these ethical decisions. Who's going to code this car? Who is going to have the decision as to where it's swerving? If it's paired with facial recognition software, you can easily see a situation where the car is reading how old the person is, if they have a criminal record, and that becomes part of the calculus as to who gets swerved toward and who doesn't. It's an interesting situation is how the ethics get legalized, what degree of public consultation should be taken in these manufacturers' decisions, and whether the law should follow or lead on this situation. Thank you.
Okay. Thank you, and I echo the sentiments of the others who've expressed their pleasure and gratitude at seeing so many of you turn out for this event. I know I stand between you and pizza, so I'll try to not go over time here. An issue that I've been working on for a little while now relates to law enforcement use of social media data analytics. And my interest, there are a lot of interesting issues, and in this research I focus on one particular case study that I'll tell you about, and it raises a lot of different complicated and interesting questions, which I try to tease out in the paper that I'm writing about it. But for our purposes here, I'll just flag that there are some really interesting privacy issues that I'm not going to have time to get into in any great detail. But I'm particularly interested in the questions of how do we know that these tools are being used, when and how. So they're really questions about transparency and accountability. So the story that interested me broke less than a year ago. It was broken by the American Civil Liberties Union in California. Essentially, the ACLU had been interested in knowing the extent to which social media data analytics were being used by police services in California. And so they set about researching this using Freedom of Information requests to try and get data about how many police services had adopted and used social media data analytics. And they came up with some pretty interesting data. The data showed that actually it was fairly widespread. The use was fairly widespread in California. But the most explosive data that they obtained was data from these access to information requests was email correspondence between sales reps for the companies and police services, in which the sales reps were essentially trying to pitch or sell just how useful their tools were. And one company in particular didn't tell its employees not to put this kind of stuff in email to government to government employees because of freedom of information, and in particular bore the brunt of this. So the company was Geophedia. And in their email correspondence with police services, they tried to persuade police services to adopt their product over the product of their competitors because they had super duper premium high-level access to social media data, to very large volumes of social media data from all of the big social media platforms. So they had lots of data. And they also had algorithms that could supplement geolocation information with respect to the different posts, because not all users would turn on geolocation. And in fact, in Twitter, it's a fairly small number that turn on geolocation. So with some tweets, you actually get geolocation data, but with a lot of them, you don't get that data. But they had an algorithm that could provide geolocation data for a vast number of these posts, which would be very interesting to law enforcement if you're going to use it for surveillance, right? And then they went on in their emails to give examples of where their product could be particularly useful to police. And the examples they gave were about the use of their product in relation to two sets of major protests, one in Missouri and one set in Baltimore, both of which related to the deaths of African-American men at the hands of police. And so they basically were saying to police, look at how useful our tool is in figuring out who's protesting against you when you kill African Americans. Anyway, so you can imagine the outcry that this generated, and it raised issues not just about privacy, and there certainly are very important issues of privacy in here, but it also raised issues about transparency and accountability, It raised issues about discrimination. It raised issues about racial profiling, freedom of association, freedom of expression. So a whole range of different civil liberties issues were raised by it. At the same time that the ACLU was doing its research, the Brennan Center for Justice was also trying to get data about the extent to which police services in the US were using social media data analytics. And they also they didn't use freedom of information requests, they used public procurement records that were proactively disclosed about procurement, and they were basically looking to see which police services in the United States had contracted for social media data analytics services and from which companies. And they produced a map, which is available online, that shows the different companies that police services had been contracting with in the United States for these services. And so what both the ACLU and the Brennan Center for Justice found was that it actually was a growing phenomenon that police were using these services. Who would have known, right? So the way it works is, of course, individuals use social media platforms. They tweet, they post stuff to Facebook, to Instagram, and so on. They understand that this stuff is being made public because that's part of the whole purpose of social networking. They also consent in those terms of use that nobody reads to this information being shared with third parties for data analytics purposes. And so there's some interesting privacy issues tied up in that I really don't have time to get into. The social media companies then sell access to this data to data analytics companies. And they sell access to different volumes depending on the needs of those companies. Geophedia, for example, was bragging that it had purchased the highest level of access. In the case of Twitter, it's called Twitter's fire hose of data, which is absolutely everything, every single tweet plus all of the metadata associated with it. And that kind of access can be quite expensive. The guesstimate is that Twitter's fire hose of data costs over $1 million a year, for example, to have access to that. So those analytics companies take this data from all of these different social media companies. They develop algorithms that can be used to mine that data for different types of insights or information. And then they sell their product, which is essentially access to the data through their algorithms to their clients, which include corporations, journalists are actually big clients of these companies, and law enforcement. Okay, so that's basically how it works. Now, Geophedia, in the backlash from this story, has since ceased operating. And in fact, within 6 weeks, it had laid off half its workforce, and the end was predictable. They could not recover from the emails, essentially, and the content of those emails. Other social media companies that were named or are identified in these studies did what in Silicon Valley they like to call a pivot, okay? Which means they changed what they did. So here's and this is an example of some of the companies that were identified as clients of, or having police services as clients. So this is an example from SnapTrends, which teetered on the brink because the social media companies, this was a public relations disaster for the social media companies, and they basically said, we're going to cut off your access if you use our data for surveillance purposes. So the pivot involves essentially saying, okay, we're not providing data analytics to police for surveillance purposes. We're providing data analytics to public safety organizations, in order to better serve and protect, which is actually the motto of the LAPD. But anyway, but it's for public safety, emergency management, and so on. And so there's kind of this rhetorical flourish here that makes it clear that it's no longer being used for surveillance, just for public safety and better serving and protecting. Okay. That's another issue. I don't have time to get into that one in any great detail. What I'm going to do with the few minutes I'm going to have left is I just want to talk a little bit about some of the transparency and accountability issues that I think are really interesting. One of them, of course, is the accountability hot potato. So individuals provide their data to social media companies. Social media companies, in their terms of service, say, and they say it even more clearly now after the ACLU released their data, they say very clearly, you can't use our data for surveillance. And these are the contracts they have with the analytics company. There is no oversight contract between two commercially sophisticated parties. There's simply no oversight, it just says you can't do it. The analytics company put into their terms of service with their clients, you can't breach the terms of service of the social media companies. and then provide no accountability or oversight. So there's basically an accountability hot potato. Everybody says you can't do it, but nobody's actually checking to see whether it's done or not. Organizations like the ACLU, Brennan Center for Justice, could be any organization, any civil society group in Canada, can use access to information to get at information in the way that was done in this case. It can be very time-consuming and very expensive to do that, but of course the big lesson learned for these companies from the Geopedia example is pick up the phone and don't say things in email that you don't want everybody to know about, right? So a lot of this stuff just disappears, and you can't get at some of the questions, which is how are these things being used and for what purposes are they being used? Brennan Center for Justice looked at public procurement data, but they note themselves that there are problems with the public procurement data because depending on who's responsible for public procurement, and it could be a single civil servant as opposed to each individual department or agency, you may see that social analytics data services are being acquired, but it doesn't say who they're being acquired by. You also don't know what the purpose of the acquisition is. Just because a police service has acquired social analytics services, is it because they're worried about their public profile and so they want to look at their popularity, their public profile, or is it because they're using it for surveillance purposes? So the data doesn't tell you everything you need to know. There are also issues about the subversion of public policies that are put in place for greater transparency or accountability. Seattle City Council required any purchase of surveillance equipment by police had to be specifically approved by council. But guess what? Social media data analytics wasn't considered by the police force to be equipment. So they just purchased it and they didn't go through this process that was meant to be public to oversee when surveillance equipment was being used. There's also little or no transparency currently at the policing level. The Brennan Center for Justice, for example, found that only 18 of 157 police services in the United States that purchased data analytics services had social media data analytics policies that they made publicly available. And so I don't have time to go into it any further. In my paper, I look at the issue of police transparency with respect to the use of social media data analytics and what kinds of things such policies should contain in order to provide some means for the public to know when these types of tools and technologies are being used and what they're being used for, and how to create some trail. So my talk is really not so much about the algorithms themselves, but it's really about how do we even know who's using the algorithms and for what purposes, and how do we manage to find ways to keep track of that. So thanks very much.